Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial Band Sleeps reading. Chapter 6, Guns and the Second Amendment. Amendment 2, 1791. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Does the word militia modify the right to bear arms? Does this mean lots of laws should govern them? Or is the right of people to keep and bear arms distinct? And what are arms? Any weapon at all? Does not infringed mean no gun regulation whatsoever? Every few weeks, another brutal mass shooting renews the ongoing national debate about the regulation of gun ownership in America. And like many issues of constitutional importance, the heated discussion often gets the law wrong. We can't address the issue of gun regulation if we don't understand the Second Amendment. Look up at the text of the Second Amendment. To me, all controversy over the meaning of this text comes down to commas. Yes, commas. In the last chapter, we spent a lot of time with the language of the First Amendment. The people who wrote that language also wrote the Second Amendment. They could have phrased the Second Amendment in much the same way as they did the First Amendment. Yes, imagine, for example, that the Second Amendment stated, Congress shall make no law abridging the right of people to keep and bear arms. Then it would be much clearer. No law abridging the right to gun ownership. Of course, abridging itself is a flabby word, as we've seen. But even if that word were used here, it wouldn't mean that zero laws infringing upon gun ownership are constitutional. Some would be okay, so long as there was a good reason for them. Most people would say that public safety is one such reason. But the Second Amendment doesn't say that. It doesn't say that Congress can't abridge gun rights. To be sure, unlike the First Amendment, it expressly refers to the right to bear arms. Right sticks out. But what does it mean by right, and where does this right come from? The question is a bit like the source of the term freedom, which is expressly named in the First Amendment. I've mentioned how some people view concepts such as freedom as deriving from natural law, some set of generalized, unwritten rules regarding the moral order of humanity. Guns probably don't qualify as part of that order, and they need not, because the Second Amendment doesn't speak of freedoms, it speaks of a right. But back to commas. By any account, the Second Amendment states that a well-regulated militia shall not be infringed, preserves the state's ability to raise militias, because militias were necessary to the security of a free state. Remember that the framers of the Constitution had just made it through a bloody Revolutionary War. They wanted independence from England, and they were acutely aware of the British temptation to march back into the colonies and take over. Moreover, in 1791, when the Second Amendment was ratified, the federal government was not the powerhouse it is today. At this point in the nation's history, there was deep concern that it not accumulate too much power in regulation to the states. Composed of regular civilians who could be called up to fight on behalf of a state in an emergency, militias were crucial to maintaining young America's hard-fought independence. The rub around commas is that, on one hand, we could interpret the phrase, the right of people to keep and bear arms, as having a completely separate meaning from the words that precede it. It is a book ended by commas, one preceding the phrase and the one after it. And those commas are important. One argument goes like this. There is an individual right to bear arms, but also a right for states to raise militias. They are two separate things linked together in one amendment by a few commas. Militias need arms to function, of course, but we aren't taking anything away from them. But the words bear arms should be pulled out of the rest of the text. What these words mean is that even without militias, individuals can constitutionally possess weapons to protect themselves against various possible threats, including those posed by their own government. The other hand is that the Second Amendment has another possible meaning. It contains no words that distinguish between the militia clause and the right to bear arms clause, or otherwise suggest that they should be read as freestanding mandates rather than as linked to the objective of maintaining state militias. It doesn't say, for example, that a well-regulated militia, being necessary for the security of a free state, is one reason why the right of the people to keep and bear arms shall not be infringed. The is one reason why is missing. It is thus equally reasonable to read the plain language of the Second Amendment as only about militias, full stop. Under this reading, all the language of the Second Amendment modifies the first clause. In other words, states' abilities to maintain militias that bear arms are necessary to the maintenance of the state's own security. After all, without weapons, a militia is hardly worth anything. If the framers were worried about limiting the ability of a new federal government to deprive states of their traditional ability to protect themselves, it is reasonable that they would make it abundantly clear that the newly formed federal government couldn't get around the militia requirement by banning states' use of weapons. Note that weapons is my word here, not the Constitution's. The Constitution refers to arms or armaments. In 1791, this mostly meant handguns or rifles that had to be reloaded before each shot, some version of so-called repeating arms. The closest thing to modern-day assault weapons that fire multiple rounds with the pull of a trigger was reportedly invented around 1779 and available in the colonies, but it was expensive. People could also make their own repeating arms, but it was uncommon. Someone who adheres to a plain reading approach to constitutional interpretation might stop there and confine the reach of the Second Amendment to what the framers understood to be arms. Semi-automatic machine guns of the modern day would not count, and that makes some logical sense, as some people don't need semi-automatic weapons to protect themselves in their homes. Ironically, a conservative majority of the Supreme Court rejected the argument that only those arms in existence of the 18th century are protected by the Second Amendment. Given what we know about constitutional interpretation by this point in the book, it is hard to discern the line at which historical practice should dictate modern thinking around the Constitution and when it should not. Somewhat conveniently, the court picks and chooses when history binds it and when it does not. At the bare minimum, this issue makes clear that there is no single, abiding, unambiguous reading of the plain language of the Second Amendment. Other factors must and do come into play, and they are not clear from the text itself. A final term that is worth exploring, also undefined, is the Second Amendment's well-regulated requirement for militias. Today, when we think of regulation, we think of laws restricting private behavior. But with the use of well-regulated in the Second Amendment, the framers perhaps meant that it was okay for states to train private people over long periods of peacetime so that they could be called up for duty as needed on a moment's notice. As Alexander Hamilton explained in Federalist No. 29, a tolerable expertness in military movements is a business that requires time and practice. It is not a day or even a week that will suffice for the attainment of it. Today, when we think of a militia, the National Guard comes to mind. It is a reserve military force composed of people from every state who aren't soldiers or military personnel. They mostly carry on with their lives and have regular jobs unless they are called to duty. Its motto and theme song, "Always Ready, Always There," sounds like a hangover from an understanding of well-regulated as meaning well-prepared and ready. Without preparation, a militia can't do what it's supposed to do. So the plain language and the history of the Second Amendment suggest for sure that militias were supposed to be protected and that militias can use arms, or at least that particular use of arms cannot be infringed upon. In common language, infringed means restricted, limited, curbed, or checked. But as we know from the First Amendment discussion, this doesn't mean that militia members can park armored trucks on their front lawns and terrify the neighbors without the government being able to say a peep about it. Restrictions abound when it comes to constitutional rights. The question is, how many are too many? How many ops you really got? I mean, it's too many options. That said, the Second Amendment is a constitutional topic that is subject to a lot of misunderstanding, at least when it comes to the governing law. So let's dispel a few legal myths about gun rights in America. And remember, by rights we mean the ability to walk into the court and force the government to withdraw or stop enforcing a law that somehow limits an individual's ability to bear arms. This is reassuring, of course, that we start from the premise that the clause separated by the two commas creates a standalone right that is not tied to the needs of a militia. As we will see, this is one assumption around which the Supreme Court has flip-flopped, and its gyrations accumulated in the now famous decision that recognized a constitutional right to own handgun for self-protection in one's home. Myth number 1. The Supreme Court has long been clear that people have a constitutional right to carry firearms. Much like paraphrase law, this is an overstatement. As we've discussed, the Second Amendment itself talks about two things: a well-regulated militia and the right of people to bear arms. Back in the day, American revolutionaries wanted to make sure breathe-in settlers could grab their muskets and join the military establishment in a crisis or fight against it. In 1939, the Supreme Court held that the Second Amendment clearly safeguards the possession of firearms for purposes of serving in a militia and must not be interpreted and applied with that end in view. That was the law for decades. In upholding a federal law banning sawed-off shotguns, the court noted that such weapons were not used by militias at the time the Bill of Rights was ratified. A classic originalist argument. The majority opinion went even further into the annals of history to justify the conclusion that the constitutional rights to bear arms was confined to militias. The court explained the signification attributed to the term militia appears from debates in the convention, the history and legislation of colonies and states, and the writings of approved commentators. In 2008, the Supreme Court reiterated in District of Columbia v. Heller that the Second Amendment says, yeah, sure, to armed militias, but crucially, it added that the amendment also protects an individual's right to use arms in self-defense. In the constitutional law world, this was a big deal. In a 5v4 decision, the court struck down a law regulating guns that had nothing to do with the militia service. So the old case was overruled to the extent that the prior court had read the various clauses of the Second Amendment together, opinion 2 previously discussed, and the current court instead held that they should be read as separate and distinct, option 1 previously discussed. Writing for the majority, Justice Antonin Scalia concluded that the former militia clause does not limit the latter grammatically, but rather announces a purpose. He then declared that purpose to be defensive. The 32-year-old law at issue in Heller banned the possession of handguns in the District of Columbia, so in its simplest formulation, the court's decision meant that you can keep a pistol under your pillow to defend yourself, i.e. to protect yourself and your family against intruders. Note that this was a big deal, not just because it declared the right to bear arms, a standalone individual right to force the government to restrict its limitations on gun ownership. It was also a big deal because the court blew up its long-standing precedent that the Second Amendment was about protecting gun possession in connection with militias, as well as the subsequent cases and laws that were based on that holding. As we've seen before, when the Supreme Court ignores what its forebears did, it can wreak havoc on lots of things. Given that few, if any, cases coming before the court in the late 20th to early 21st century are cut and dried under the language of the Constitution, there is an argument to be made against this kind of second-guessing period. One problem is that it makes the court appear political and not neutrally tethered to the law and the facts. When the Supreme Court is perceived as politicized, whether rightly or not, its legitimacy falters and people lose faith in the integrity of the judicial system as a whole. This is not to say that it's wrong to overrule precedent in all cases. Infamously, the court held in Plessy v. Ferguson, discussed earlier in the book, that separate but equal treatment of racially segregated African Americans was constitutional. That's an example of a constitutionally based decision by the Supreme Court that was dead wrong, and the court rightly overruled Plessy and Brown v. Board of Education. But in my humble opinion, if the court is to turn precedent on its head, it should probably do so unanimously, or not at all. Note, too, that allowing D.C. to regulate handguns, the opposite of what the Supreme Court said in Heller, would also be justified on federalism grounds. Recall that federalism is shorthand for the dividing line between state and federal power. The notion is that one way to confine the power of the federal government is to guard the power of the states. The D.C. handgun ban was a local law supported by local residents regarding how they wanted to solve problems inherent in living and working in their own community. In dissent, Justice Breyer argued that the district's decision represents the kind of empirically based judgment that legislatures, not courts, are best suited to make. He also argued that a reasonableness test should be applied to gun bans, something like the lowest level of scrutiny, again it's known as rational basis, that the court applies to other kinds of rights protected under the Constitution. The majority struck down the handgun ban without showing its hand as to what level of scrutiny, strict, intermediate, or rational basis should apply in future gun cases. Myth number 2. Arms necessarily include handguns, rifles, and semi-automatic weapons. This one is also off, as I previously indicated. Arms is not defined in the Second Amendment itself, but would anyone seriously argue that it means your neighbor can store plutonium in his garage and make a nuclear bomb to protect his family? Of course not. What the Supreme Court specifically found in Heller was that handguns can be kept and used in the home for self-defense. The court then laid out a bunch of factors that may be important in deciding if something else constitutes arms under the Second Amendment, including whether a weapon is one that musket-bearing settlers would have commonly used, and whether it's dangerous and unusual. The courts also carved out areas where the right can be limited, such as for mentally ill persons and felons in or around schools and government buildings. The justices don't even want cameras in their courtrooms, let alone machine guns. Myth 3. Gun ownership is a Second Amendment issue, period. This one gets us into the wonky world of separation of powers theory, but it's of vital importance. These days, the Supreme Court is the branch of government that's basically drawing the lines on gun use. But should it? Our state and federal legislatures make rules too, and we elected them. When a matter is enshrined in a Supreme Court decision that interrupts the Constitution, it's very hard to change even by Congress. Thus, we might think twice about making gun safety first and foremost about the Second Amendment. Of course, this argument could overstate the point, in that we can't have legislatures overriding the Constitution all the time. If the Supreme Court says X, legislatures must abide by that, and it's the Supreme Court's job to say so. But as we've seen, constitutional provisions don't always say X in an unambiguous prose, and the Second Amendment is one of those provisions. Keep in mind that while bans on gun ownership have been struck down as unconstitutional, stand your ground laws exist in a number of states, which protect people from criminal prosecution if they injure or kill someone in perceived self-defense rather than retreating. To be clear, these laws give immunity to people who use violence in alleged self-defense, even if they could have protected themselves by retreating. In many cases, the only witness who is in a position to argue against the self-defense claim is dead. If this is the will of the public enacted through legislature, should courts get involved? Critics point to the multifold increase in self-defense claims following enactment of such laws as evidence that they encourage violence. Some also argue that the defense is more effective when used by whites to justify violence against blacks than vice versa. Laws passed electorally are not set in stone. The Constitution is the law of the land, and voters cannot agree to bypass it. For example, voting to exclude black people from lunch counters. Those days are over. But the tension between respecting the will of the people through legislatures and restricting the will of the people through constitutional interpretation is intense, and resolving that tension puts an extraordinary amount of power in the hands of the 9 individuals of the U.S. Supreme Court. Myth number 4. The Second Amendment right to bear arms is sacrosanct, so any limits on it are unconstitutional. Wrong. Regardless of which side of the political aisle you are on, this is incorrect. Lots of constitutional rights have limits. In Heller itself, Justice Scalia wrote, "Like most rights, the right secured by the Second Amendment is not unlimited." Through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapons whatsoever, in a manner whatsoever, for whatever purpose. This part of the Heller holding might come as a surprise to many of you who might have gleaned through popular culture that the Second Amendment is impenetrable. Think about the First Amendment right to free speech, which we have just discussed. It's pretty foundational to American sensibilities, but we treat government restrictions on religious and political speech differently than we do about speech via child pornography or threats to the U.S. president. It's all about balancing. We balance the good things about free speech with the bad things about free speech, and we make a call. We draw a line, often through the Supreme Court. When it comes to gun violence, we might agree that the line can be drawn at nuclear weapons in the home. Some might draw it at automatic weapons or semi-automatic weapons with bump stocks, or at mandatory background checks or safety training or post-purchase cooling off periods. The question comes down to this: does the Second Amendment right to self-defense outweigh the heightened dangers of increasingly lethal guns? U.S. assault rifles were engineered by Germans in World War II, when commanders realized they needed more powerful battlefield weapons. Compared to standard guns, they are harder for law enforcement to counteract. They increase the risk of hurting and killing bystanders, and they inflict greater damage on human flesh. If the shooter who killed 20 small children at Sandy Hook Elementary School hadn't had to stop and reload 9 more youngsters, might have not managed to escape the carnage. The question for us all is not whether to draw the line. The Supreme Court has already answered that is a yes many times over, but where? The government cannot take away all guns. That is clear and undisputed. But the government is not constitutionally forbidden from restricting guns either. That is clear and, at the Supreme Court, also undisputed. And that was Chapter 6 of How to Read the Constitution and Why by Kim Wehle.